Welcome to this explainer. Today, we're embarking on a masterclass into a fascinating subject that silently governs the vast majority of our planet, maritime law. Think about this for just a second. Nearly 90% of global commerce travels by water. The device you're using right now, the clothes in your closet, and the shoes on your feet likely crossed an ocean governed by the exact, highly intricate web of rules we're about to unpack. From multi-billion-dollar shipping lanes to sunken pirate treasure, if you've ever wondered how our global waters are actually governed, well, you are in the exact right place.
All right, let's dive right in. Here's how we're structuring this deep dive. 1. Defining maritime law. 2. History of the high seas. 3. Core rules and mechanics. 4. Treaties that shaped the seas. 5. Global variations in law. And finally, 6. The future of maritime law.
First up, Pillar 1. Defining maritime law.
Now, people mix up maritime law and the law of the sea all the time, but understanding the difference is absolutely critical. The law of the sea is international law regulating the relationships between sovereign states. It dictates those massive geopolitical questions, like exactly where our country has the legal right to drill for offshore oil. Maritime law, which is our focus today, is a branch of both public and private law that regulates the actual activities, human use, and legal relationships of marine navigation. Practically speaking, while the law of the sea handles the oil drilling rights, maritime law dictates who actually pays up when two private cargo ships crash into each other in the fog. It's overseen by specialized agencies like the International Maritime Organization and the International Maritime Committee. And interestingly, its autonomy as a distinct branch of commercial law has been fiercely debated since the 17th century, starting over in France with the Colbert Ordinances.
Moving on to Pillar 2, the history of the high seas.
Exploring how all this began brilliantly illustrates a simple truth. Trade has always necessitated regulation. It started way back in the Byzantine era with the Nomos Rhodion Nauticos. Things got heavily formalized in the 12th century when the French queen Eleanor of Aquitaine learned about maritime laws during a crusade with King Louis VII, and she subsequently introduced the famous rolls of Oleron to England. By the 14th century, the Guidon de la Mer in Rouen added highly specific rules for marine insurance, and incredibly, these ancient codes helped fuel the American Revolution. See, the British Parliament used admiralty courts to enforce the wildly unpopular Stamp Act. Why? Well, because maritime courts were controlled directly by the Crown and operated under civil law, without a jury. This let the British completely bypass sympathetic colonial juries. This direct deprivation of a fair trial outraged the colonists so deeply that John Adams pushed for protections that ultimately became the Seventh Amendment to the U.S. Constitution in 1789.
While European codes were taking shape, Islamic law was innovating in a huge way, with stark contrasts in human rights and labor laws compared to Roman and Byzantine traditions. Under the Roman and Byzantine systems, sailors were essentially viewed as interested parties in a venture. They only got a proportionate cut of the profits after a completely successful voyage. Islamic law, however, created a totally different environment for the worker by providing sailors with a fixed salary paid in advance. Islamic scholars also clearly differentiated between coastal navigation and highly dangerous high-sea voyages, and they explicitly broke away from the Digest of Justinian by firmly condemning the eviction of slaves. It's totally fascinating how both Roman and Islamic influences fundamentally shaped the worker rights and the international legal framework we rely on today.
Okay, Pillar 3, core rules and mechanics.
Remember those 12th century rules of Oleron we just talked about? Well, they established a doctrine called medical maintenance that is still fiercely enforced right now. A ship owner is strictly obligated to provide a sick or injured seafarer with basic necessities and treatment until they reach the maximum of medical cure. This means even if a sailor will never fully recover, treatments that keep them functioning well, we're talking wheelchairs, prosthetics, ongoing pain management, must be provided. And courts do not mess around with this. In the 1962 Supreme Court case Vaughn v. Atkinson, it was ruled that seafarers can recover all their lawyers' fees if they're forced to sue for these medical costs. Even more striking, in the 2009 case Atlantic Sounding Cove, Townsend, the court ruled that if a shipowner deliberately and wantonly violates this obligation, they can be hit with punitive damages. For a massive maritime corporation, opening the door to punitive damages is a literal nightmare.
So, a crucial point here is how the law handles disaster and rescue at sea. And honestly, it features a brilliantly absurd bit of legal logic. Under maritime law, there is absolutely no monetary reward for saving a human life. Saving a life is just considered an implied moral obligation. Salvage rewards apply strictly and exclusively to saving property. You pull a drowning sailor out of freezing water, you get a moral pat on the back.
You pull up a sinking chest of gold, you get a massive payday. We generally see two types of property salvage. Contract salvage is exactly what it sounds like. The rescuer and owner agree on a price beforehand, like the famous Lloyd Open contract. But pure salvage or merit salvage is where no contract exists. You save the property, bring it to a judge, and the court calculates your reward.
Now, to calculate that pure salvage reward, courts weigh a really fascinating mix of factors. It's almost like a giant puzzle. They look at the danger involved, so differentiating a high-risk, high-order rescue in a violent storm from a low-order rescue where you're just towing a stalled ship in calm seas. They also look at the value of the rescuer's risked property. If you risk a $50 million vessel to save a $10 million vessel, your reward scales way up. But the absolute foundational rule of pure salvage is this: no cure, no pay. This means a rescuer could spend millions of dollars and weeks of time trying to save a ship, but if it ultimately sinks, the rescuer swallows that entire loss and gets absolutely nothing.
Usually, standard pure salvage rewards rarely exceed 50% of the saved property's value. But sunken treasure? That completely changes the rules. Wrecks like legendary Spanish galleons, World War II German submarines, or Civil War vessels have been lost in the deep for centuries. The original owners or their heirs technically still retain an interest, but because deep-sea recovery requires such immense speculative capital, courts often reward prospectors with the vast majority of the treasure's value. And this whole area of law has exploded recently thanks to side-sweep depiction. This is an incredibly advanced sonar technology that maps the seafloor and creates highly detailed photographic-like images of the deep. It makes it vastly easier to pinpoint these lucrative historical artifacts, completely sparking a high-tech modern era of treasure hunting.
Now, if you ever plan on taking a cruise, you really want to listen up, because passenger injury claims are a legal minefield. Ship owners owe you a duty of reasonable care, but the burden of proof is entirely on you to prove they failed. Plus, the strict timelines are severely stacked against you. Standard personal injury cases usually give you 3 years to file a lawsuit. But if you are suing a cruise line, the fine print on your ticket usually restricts you to just 1 year and demands official notice of the injury within 6 months. Cruise lines also employ aggressive liability defenses. In a very famous 1954 UK case, Adler v. Dixon, a passenger was severely injured by a boatswain's negligence. The shipping company successfully evaded liability using a slick contract trick known as a Himalayan clause. A Himalayan clause essentially extends a company's own liability protections and limitations down to its employees and third-party contractors, successfully shielding everyone involved from being sued individually by the injured passenger.
All right, zooming out to Pillar 4, the treaties that shaped the seas.
The modern era of maritime treaties really kicked off with the Paris Declaration of 1856, which effectively ended the Crimean War. It established huge principles to humanize naval conflict. The biggest one was abolishing privateering. Privateering was essentially state-sponsored piracy, where governments gave private ships letters of marque, legally allowing them to attack and loot enemy trade vessels. The declaration also protected enemy loads under neutral flags, protected neutral cargo under enemy flags, and demanded the blockades actually be effective, not just declared on paper. Interestingly, the U.S. refused to formally accede to the whole treaty because they wanted the Marcy Amendment included. This amendment aimed to protect all private property at sea from being seized. Why? Well, at the time, the U.S. had a massive, highly lucrative merchant fleet, but a very small navy, making them uniquely vulnerable to British confiscation.
This diplomatic momentum led right into the Hague Peace Conferences of 1899 and 1907. Driven heavily by the Russian Empire, these were uniquely held during peacetime to proactively seek disarmament and humanitarian restraint. They established the International Court of Arbitration and officially applied the Geneva Convention to naval warfare. It was a beautiful, deeply complex humanitarian framework. But honestly, it also represents a massive historical tragedy. The world spent years carefully crafting these peaceful laws, only to instantly toss them out the window the second the guns of August 1914 started firing, as warring nations completely abandoned the agreements to prioritize military survival in World War I.
Following World War II, the global community tried again, culminating in the foundational modern treaty, the UN Convention on the Law of the Sea, or UNCLOS, which became effective in 1994. UNCLOS elegantly divides the massive regulatory burden. The IMO handles the physical ships, overseeing safety, pollution, and security. Meanwhile, the International Labor Organization regulates the human element, the living and working conditions of the crews. And here's a really vital detail regarding the United States. The U.S. actively helped draft UNCLOS and relies heavily upon it, but has never actually ratified it. However, the U.S. considers itself legally bound by the treaty because of customary international law. This is a legal principle where a rule becomes so universally accepted and practiced by the globe that it becomes legally binding on everyone, even nations that refuse to officially sign the actual piece of paper.
Pillar 5. Global variations in law.
And this brilliantly illustrates just how wildly inconsistent domestic laws still are today. Despite grand international treaties, local rules are all over the map. Spain recently consolidated its laws into a brand new text with Law 14/2014, sanctioned directly by King Felipe VI. Russia operates under its 1999 Merchant Shipping Code. Germany governs its waters via the 5th book of its Commercial Code, which finally underwent a massive modernization reform in 2013 to update completely outdated norms. Then you have Belgium, which uses the Belgian Shipping Code. This is an evolution of a 19th century act that actually relies on the legal DNA of an ordinance written by the French Sun King, Louis XIV, way back in the 1600s. This massive span of time really highlights how incredibly varied global waters can be from one coastline to the next.
Over in Brazil, things are uniquely complex. Much of their maritime activity is still inexplicably regulated by the only unrevoked section of their 1850 Commercial Code. And they have this massive, ongoing doctrinal conflict regarding terminology, drawing a very sharp line between maritime law and navigation law. Maritime law mixes public and private, while navigation law covers only the public sphere but includes both sea and airspace. So why does this doctrinal conflict actually matter? Imagine a modern scenario where a commercial drone or a seaplane crashes into a cargo ship in a Brazilian port. Because of this rigid distinction, lawyers will spend years just arguing over whether maritime law or navigation law applies before they even begin to determine who is actually at fault.
The Netherlands gives us a great look at how nations practically manage overlapping borders. With critical maritime zones in both the North Sea and the Caribbean, they manage their territory via the Dutch Territorial Sea Borders Act. When their maritime zones overlap with neighboring countries and no specific treaty exists, they use pure math, defaulting strictly to the UN close rule of the equidistance line, basically drawing a boundary at an exact equal distance from both coasts. But while they use math to solve local disputes, enforcing their power on the high seas has changed. The Dutch Navy spent centuries solely protecting their own high seas shipping interests. Today, however, to protect massive global shipping networks, they, like most modern navies, have transitioned to almost exclusively acting together in international naval coalitions.
Finally, Pillar 6, the future of maritime law.
Look, this industry is moving at breakneck speed. To ensure this ancient legal framework actually survives, some massive steps are required. We desperately need periodic legal reviews of these codes. We require highly specialized training for legal professionals to navigate these complex global disputes. We need to foster aggressive collaboration between governments, businesses, and civil society. And we must launch targeted public awareness campaigns. Because with the advent of AI and fully autonomous ships, updating these laws isn't just bureaucratic housekeeping. It's a matter of critical global security and environmental protection.
So, we've seen how maritime law evolved from Byzantine codes and the Crusades of Eleanor of Aquitaine to regulating multi-million-dollar salvage operations and vital global environmental treaties. It truly is the invisible, ancient force keeping 90% of global trade afloat today. But it leaves us with a pretty intensely provocative final thought. As technology like deep-sea mining, artificial intelligence, and autonomous shipping rapidly advance, how on earth will a foundational legal framework written in the 12th century adapt to govern the high-tech, crewless cargo fleets of tomorrow? Thanks so much for joining me for this explainer. Keep learning, and I'll see you next time.